more space than this. But welcome, good morning. I'm Dean Jessica Berg. I'm thrilled to see all of you here. We are really excited today that we're going to welcome the 8th District Court of Appeals for oral arguments. My pleasure to introduce our panel who will be joining us in just a moment. We have 3 esteemed judges. We have Judge Lisa Forbes, who was elected to the 8th District Court of Appeals on November 3rd, 2020. Prior to joining the bench, Judge Forbes was a partner in the Cleveland office of Voorhees, Sater, Seymour, and Pease, where she practiced in the area of complex litigation. Judge Forbes graduated summa cum laude from Case Western Reserve University School of Law in 1992. She served first as an associate editor on the Law Review and then as executive notes editor. Also joining us on the panel is Judge Emanuella Groves. She was elected to the 8th District Court of Appeals on November 3rd, 2020, her term commencing February 11th, 2021. Prior to her election, she served as 18 years as a trial court judge in the Cleveland Municipal Court, where she was first elected in 2001. Judge Groves also attended Case Western Reserve University School of Law, graduating in 1981. She proudly has returned to the law school, both for this and other things. In 2016, she came actually as an adjunct professor and taught criminal procedure 2 before she ran for the Court of Appeals. The third panelist is Judge Michelle Sheehan. She was elected on November 6th, 2018. Prior to being elected on the Court of Appeals, she was a shareholder at a large litigation firm and litigated both state and federal court cases on behalf of both plaintiffs and defendants for over 25 years. She received her JD degree from Cleveland Marshall College of Law. All 3 of our judges on the panel have been frequent and helpful visitors here at the School of Law, whether for this oral argument event, helping with the Dunmore Moot Court competition, or serving as a speaker or panelist at different events. We also have Judge Cornelius Sullivan, Jr., who will join us. He was appointed to the court on December 15th, 2021. He's going to join us for the question and answer part of this, but not part of the panel. Prior to being appointed, he was a partner in a large litigation firm and practiced law for over 60 of Ohio's 88 counties. He has 30 years of legal experience and over 26 years in civil litigation. He earned his Juris Doctor degree from Cleveland Marshall in 1990, where he was editor of the Law Review and, perhaps most interestingly, a member of the flag football team that won the championship for the entire university. Pretty impressive. So without further ado, I'm going to turn things over so the proceedings can get started. Please remember that this is an active court session. Cell phones and other kinds of things should be silenced. Please do that now. Otherwise, we are extremely excited about this event and look forward to hearing the arguments. Thank you all. To make a room adjustment.
Hear ye, hear ye, hear ye. This session of the Honorable Court of Appeals, 8th District, is now open pursuant to adjournment. The Honorable Michelle J. Sheehan presiding. You may be seated.
Good morning, everyone. Welcome to the 8th District Court of Appeals. And while we're physically here at Case Western Reserve University School of Law, we are acting as if this is in the courtroom at the 8th District. So thank you for joining us. I just wanted to go over a couple preliminary matters before we start. First, this argument is being recorded, audio recorded, pursuant to our Appellate Rule 21J. And secondly, as you may or may not know, hopefully the participants are aware of this, you each have 15 minutes to argue. The appellant, if you want to reserve any time, just let us know that when you begin. With that said, Ms. Bailiff, would you please call the first case?
Our case is case number 111330, State of Ohio versus Jessica Berg.
Appellant, Mr. Baker?
Good morning, Your Honors. May it please the court, my name is Aaron Baker. I'm here to argue on behalf of the appellant, Jessica Berg. I would like to reserve 5 minutes for rebuttal argument.
I should add that Ms. Elmore will be taking time. When you hear the beeping, you'll know your time is up.
Your Honor. At the outset, it's important to note that although we're only dealing with one assignment of error in this case, there are two distinct arguments within that assignment of error. Both are suppression related pursuant to a traffic stop. The first question is whether the stop was proper, whether there was reasonable suspicion to stop Ms. Berg's vehicle for a traffic violation, which in this case was a marked lanes violation, according to the testimony of the officer. I believe that as I submitted in my briefing, that the dash cam video supports that there simply was no marked lanes violation, and that's pursuant to the Ohio Supreme Court case of State versus Turner. The accusation here is that there was a marked lanes violation, that she crossed the fog line. She did not. She touched the fog line, and the holding in Turner is that that's acceptable. That's not a marked lanes violation. It's permissible to touch the fog line on the right side of the roadway, and you're still not committing a traffic violation at that point. And if you look at it in the context of the fog line, that actually does make sense. Fog line is there merely to warn you that the side of the road is upcoming. There's no traffic going in the alternate direction. There's no traffic going in the same direction. It's not another lane on the other side of the line.
So you're taking a hard line that she absolutely did not cross the line.
She did not, Your Honor. And in fact, I believe that the screenshot that I submitted in my briefing was fairly cropped from the video, that she went no further to the right, and she certainly never came off of the white line crossing it. She touched the line.
But the standard here isn't metaphysical certitude, it's reasonable. And so given the split second in which the alleged infraction occurred, isn't it reasonable for the officer to have considered, given how close to the line or how potentially close to the line she did come, that in that instant it was reasonable for the officer to perceive or appreciate that he had probable cause to stop. And I'm going to ask you that, and then I have a follow-up question.
I appreciate the question, Your Honor, and I don't believe that that's what reasonable suspicion means in the context of the case law that I've submitted. In other words, it's not what the trial court found, and this is what goes to our mixed standard of review here. The mixed standard of review being that with regard to the facts that the trial court found, they must be supported by competent, credible evidence, I believe are the exact words. And then the law is reviewed de novo. So what the trial court found was that the officer had a good faith belief that she crossed the line. And that's not the standard. It's an objective standard. Was there a traffic violation or was there not? And I believe that you will find that all through all of the case law that I submitted earlier this week, which I believe was just 2 days ago, maybe 3 days ago. In those cases, you will find again and again, in Hampton in the first, in Benj, Gordon, and Franklin in the fifth, in Barr and Ali in the sixth, in Lee Sack in the 11th, and in Massot in the 12th, you will find again and again that we take the word of the objective video evidence over the word of the officer.
It's an interesting concept because Our review is to defer to the trial court for findings of fact, right? And now we're introducing a video that we're essentially reviewing it de novo.
Well, it's not that you're reviewing it de novo. You have the same opportunity to review that video that the trial court did, and I believe you'll find in the record that the trial court in its deliberations outwardly said they did not review the video, that there was no way for them to get the video to play, but then went on to say, but I saw it in the courtroom. So
I know Judge Forbes had a follow-up.
I do. Can I do go ahead and my follow-up? So my follow-up has to do with this question of reasonable suspicion as distinct from probable cause. Now, you're asserting that what was necessary was for the officer to have reasonable suspicion of a traffic violation. So I two subparts here. Is reasonable suspicion less than probable cause?
it is something less than probable cause. Your Honor.
And is there case authority that supports that you need reasonable suspicion to make the traffic stop as distinct from probable cause to make the traffic stop?
Yes, Your Honor. I don't have that case law in front of me right in this instant, but I believe you will at least find it in the case of State versus Turner that I've cited too heavily from the Ohio Supreme Court regarding the fog line issue. While reasonable suspicion is a lesser standard, our submission is that it is not reasonable to suspect a traffic violation that did not occur.
In reviewing the statute, and help me understand if this is even relevant at this point, but the statute says 2 lanes. There were no 2 lanes.
Correct.
And so, in looking at that, how relevant is that factor to be considered before you even get to that she allegedly crossed the line? And how can we consider that if it was not raised at the trial level?
I think it needs to be viewed in the context, again, of Turner out of the Ohio Supreme Court, because what they did there was they took a look at, I believe, what they referred to as the MCUD, and I can't recall, or the MUTCD, which is the Manual of Uniform Traffic Control Devices, and specifically Section 3A.06b of that manual. And you'll find that in paragraph 3 of Turner, that reference. And the reason that I refer to that is because that manual deals specifically, that portion of the manual deals specifically with the fog line issue in the context of our marked lanes statute.
But the preference of the statute is that 2 or more lanes.
True. And
It was 1 lane. It was the berm.
there was.
So
And
is that applicable to violate if there aren't 2 lanes, is my question.
I don't know the answer to that, Your Honor. I haven't considered that up until you just asked it, honestly, because my end point in researching this was admittedly Turner, because the Ohio Supreme Court said it's okay to drive on the fog line, and that's all she did. So it's not a traffic violation. It doesn't give cause rise to a stop. And what I want to turn to quickly, because I'm under limited time here, is because there is this second prong. If you resolve the first prong in my favor and find that the stop should have been suppressed, we're done, in my opinion. I don't believe we even move on to the second portion of this, and that gets into bringing the canine out to sniff the vehicle because the officer simply wasn't satisfied with the answers he received from Ms. Berg. I have on the time code, and I urge this court, if you haven't already, to, when in reviewing the dash cam, if you look at the time code in my experience only appears if you use the VLC media player software. And in fact, I think I put that in a footnote in my brief. If you use any other software, that time code at the bottom of the screen just doesn't seem to appear. I'm not sure why. But referring to that time code, at 11:05 in 42 seconds, the stop commences. At 11:08 and 15 seconds, we have full compliance by Ms. Berg with turning over her license, turning over the rental agreement for the vehicle, and answering all of the officer's questions. At 11:08 and 58 seconds, by radio, you hear the officer learn that her license is valid, the registration for the car itself is valid. At 11:42 seconds, you hear the officer tell Ms. Bird that he is only going to write her a warning. It's almost exactly 8 minutes later that the sniff starts. Now, the warning is this. It's 3 lines. There's several boxes in there, but it's 3 lines of text. I believe it's fair to say that this should have taken about 1 minute to fill out. If we're being charitable, let's say it's 2. If we're being really charitable, let's say it's 3 minutes to fill this out. 1 minute per line. 3 minutes from 11:42 is 11:14:42, and you still have 5 minutes where Ms. Bird could have been down the road before the canine even begins the sniff. And then, of course, there are ancillary questions here that I don't necessarily know are relevant. Why did the canine alert in the first place? Because there were no drugs in the car, and there is no canine I'm aware of that is trained to detect the presence of a firearm.
But none of that.
Before you get to that question, why was there even a need to request K-9? What is your understanding? What was the sufficiency of the evidence for the K-9 to even be called?
Being fair to the officer, his answer was that, well, Ms. Bird's answers to his questions, which I'm unsure of why he was asking in the first place, weren't adding up. She initially said she was coming from North Olmsted, but she was getting off at Bagley and heading north. So North Olmsted didn't make any sense. But then she did quickly later correct herself and say, maybe I was confused and thought I was referring to North Royalton, which even living in North Royalton, I've done that myself. I get mixed up because we have so many suburbs here and they're similarly titled suburbs. So there really was nothing suspicious about her behavior here. There was no reason to question
Gave
her.
her
on
every
this.
opportunity where she was coming from, and I know your brief said, well, she just might have been confused North Olmsted versus Strongsville, but he gave her multiple opportunities to clarify. Does that matter?
And I believe she did. And I believe she largely gave the same answers. The only material change I noticed in her answer from one question to the next was the correction of maybe it was North Royalton I was coming from.
Oh, go ahead. You have another one before?
I do, if I may.
Absolutely.
So the question I have about that is that the suspicion, the reasonable suspicion that was necessary for the officer to extend the stop into what I think the trial court called the second mission.
Yeah.
The reasonable suspicion of, it's a reasonable suspicion of criminal activity. Is there and what about being confused about coming from North Railton versus North Olmsted or getting a drink or going to Aldi's creates reasonable suspicion of criminal activity?
To be short, none of it. None of it indicates criminal activity. It indicates confusion at most, and confusion does not give rise to the thought that she's committing a crime.
I don't have any more questions. Your time has expired.
Yeah, I will reserve
And
the balance
reserve
of my time.
rebuttal.
Thank you, Your Honor.
Morning, Ms. Harrison.
Good morning. May it please the court, your honors. Alicia Harrison on behalf of the Appellee in this case. I do want to begin with the first issue that Mr. Barker started with, whether the traffic stop in itself was warranted. I would like to highlight as well that when reviewing suppressions in regard to cases like this, the deference is given to the trial court. The trial court has the opportunity to observe and determine credibility of witnesses, in this case only being one witness who was the officer that ultimately pulled Ms. Bird over. Turning to Turner, the Ohio Supreme Court case that was relied on by the trial court but was also relied on in the Appellee's oral argument initially, the trial court relied on that in making its ruling and differentiated between Turner states that going on top of the fog line or touching the fog line wasn't sufficient. And in this case, what can be seen on the video and, well, further was testified to in the suppression hearing is that she is over or on the line, if not the entire tire is on the line. And then the court further explains in their ruling that even though it's difficult to see, even though it's hard to tell in the video recording of it, pairing that with the testimony of the officer in this case, who was under the belief at that time that she did cross the line, that was sufficient, that belief was reasonable for him then to initiate a traffic stop as a result.
Well, does it matter, like I asked the appellant, it's an odd situation where we're reviewing the factual findings of the trial court with deference to them, but we're given a video that we're seeing at the same time the trial court's seeing it. So can we look at that video and view it differently than the trial court and make our own conclusion under the standard of review?
I think it's a touchy area, certainly, with giving the deference to the trial court. Obviously, in each case, with the record, this court has the ability to review all exhibits or anything that's ever been submitted in a trial or in a hearing. But whether there's, more consideration given from your eyes, today or in your deliberations than from the trial court judge, I'm not sure. I'm not sure, if that's something that's what the standard is referring to when it's asking this reviewing panel to give deference to the trial court judge who initially heard the issue, reviewed all of the evidence, and heard specifically from the witness in this case.
Oh, gosh. No, I was going to help you out a little bit. I suspect, and correct me if I'm wrong, that if we have to defer to the trial court for findings of fact and conclusions of law, unless there's clear and convincing evidence, otherwise our review would have to show there's clear and convincing evidence that he's wrong on his factual findings.
Correct. So it all comes down to that competent, credible evidence. And if what Judge Corrigan in this case, reviewed and determined, if you find that his rulings in light of that was not based on competent, credible evidence, that's the only way that this, you would then not defer to him in this scenario.
And so what impact, if any, does the fact that the trial judge states in open court when he renders his decision that he was unable to play the video, so he just had to rely on what he saw during the hearing because he couldn't separately review the video?
So it's kind of a unique scenario where I was the prosecutor that handled the suppression hearing in this case. So I, taking my word for it, it was played multiple times in the hearing. I know there was some issues for some reason, you can tell in the hearing throughout the transcript, and then also based on that comment with the disc that was made and replaying that disc. But certainly when it's played in the trial court, in the courtroom, it's on a large screen. It was played multiple times, certainly giving deference to that judge. If it was something that he didn't recall correctly or wanted to review, I'm certain he would if that was a scenario.
So is there a suggestion then that we are to ignore what our eyes see and allow the trial court to say that their eyes are better than ours and we see something differently?
No, not at all. So, and I think that's what comes down to what Judge Sheehan was mentioning is whether that evidence, the video in this case, paired with the testimony from the officer, is competent, credible evidence for the trial court judge to make that decision and base his decision on all of that. I think that's what the determination comes down to in reviewing the video. If that's something that is found credible by this court, and the testimony by that officer is found credible and competent as well.
I also want to ask, and because I did traffic for 18 years as a trial court judge, so does this court just ignore the fact that it was not 2 lanes?
And the interesting part when you ask that question to the appellee is clearly throughout a lot of the case law that's cited, the supplemental case law that was filed as well, there's so many distinctions about specifically this statute that have been litigated. Whether it is a traffic violation going over the fog line, whether it's a traffic violation while driving on the fog line, whether it's a traffic violation crossing over on marked center lanes. So certainly I would defer to the case law that's been litigated for it out there, but there are multiple different jurisdictions, which eventually leads Turner. The Ohio Supreme Courts have to make the decision in Turner because it is litigated both ways and it is decided both ways throughout the state.
But to have a marked lane violation, there must be two. My question is, do we ignore the fact that statute is really not
I don't say you ignore that, certainly. I think it's something to consider.
I'm not sure where you're going to go next, but I do want to make sure that we address the assertion in Appellee's brief that the basis for pursuing the search was consent. And there's no citation that I could see to the record where the state identified where consent was given. And so I want to ask you to direct that and also to address the question of whether we can even really consider a consent argument at this stage of the game, given that that was not the basis for the state's argument below.
Yes, and I'll clarify that argument. So specifically looking back at the record, reviewing the video, when Ms. Bird is taken out of the vehicle, the officer asks if he can pat her down for weapons, essentially search her person for weapons. At that point, she consents. At that time, she has a fanny pack around her right here that she has kind of like clutched near her arm. She consents at that time to the search of her person. So it's our position at that point, knowing that she has, a loaded firearm in that bag that's attached to her at that point, she's consenting to that search. So differentiating that from there is not a time where she consents to the search of the vehicle, but specifically consenting to the search of her person at that time. But what ends up happening is the officer says, take the bag off, set it over here, and then puts her into the vehicle and only searches her.
Consent, are you arguing the consent extended to the point when they put the fanny pack in the car that they could then open the fanny pack in the car?
No. I'm stating at that point she certainly was aware. There was a great opportunity of that firearm being recovered when she consents to him physically patting her down while that firearm is essentially attached to her.
So at the point then that there was a prolonged stop, consideration is given that then the seizure became unlawful, or does the unlawful seizure override any issues?
So at that point, the officer is, and I think there's case law that supports this as well that's cited in our brief, has the ability to apprehend or to secure an individual while an investigation is done, even in the case of a traffic stop. At this point, I would argue that investigation is now bled over into possibly something else. The officer has testified to when he approaches the vehicle, she's nervous. He can tell she's nervous. He tries to calm her nerves a little bit. It's not working.
Do we ignore the fact that she was a black woman?
No, not at all. And I know this court certainly has ruled that that's not something not to consider in a scenario like this. But specifically looking at the officer's investigation, it wasn't just the nervousness. Initially, I think maybe his first indicator was the story that wasn't making sense paired with the nervousness is what kind of raised concern to him.
Can I ask the question that I ended with Mr. Baker? What about being confused about, or to the extent there was any confusion, because her story really does not ever change. She keeps answering the exact same way. He just keeps asking her the question. She keeps answering the question. So what about the fact that she went to North Royalton to a speedway, which she offered the officer to look at her phone and see that she had pulled up in directions for that. What about that then driving to Middleburg Heights to go to an Aldi? What about that is suggestive of criminal conduct?
So initially, and what the first statement she makes is that she's coming from Great Northern, which is in North Olmsted. He ultimately sees her vehicle go on 71 North, which would be going in the opposite direction, that she would be coming from Great Northern. So that raised a red flag. At that point, she states, I meant to explain I was going from Great Northern, then I went to North Olmsted to go to a speedway. The officer had
She went to North Royalton.
North Royalton. Now I'm doing it. So he indicates that there was a speedway near Great Northern. So it seemed suspicious to him that she would drive from one end of town essentially to the other end of town and then come back near in the middle, paired with her, apprehension when he pulled her over. That he wanted to determine whether there was any further criminal activity afoot, which I think he explains in the record was he was thinking either drugs or firearms, which is what he'd seen in his experience.
And I guess I have to ask, what role then does the trial court's reliance on the fact that she was apparently hugging the steering wheel before she exited 71, what role does that play in this analysis? And what about, again, about driving, holding a steering wheel cautiously is indicative of criminal conduct? I didn't see that explored further in the record.
And if I recall correctly, I believe the officer's understanding was sometimes when people are driving too cautiously, it's almost overcorrecting. And at that point, can raise some sort of suspicion. Obviously, that certainly is not enough to pull someone over if you just see them hugging a steering wheel. But it's what drew his attention to that vehicle specifically.
So then, okay.
So if we take in consideration that we can't ignore the fact we take away the fact that what difference is it's left to because I know I will pull myself to the steering wheel, especially if I'm tired, if I'm not sure or whatever, I will do that. So we take those two things away. What left do we have for reasonable, articulable suspicion?
Well, I think the concern is we can't take all of those things away. What's determined at the trial court is all of these need to be taken into consideration in the totality of the circumstances of what the officer viewed and then ultimately determined. So without those things, it's her story kind of not adding up, the route that she took not making sense to the officer that then raises concern, but pairing that with her nervousness and hugging the steering wheel, then looking at it in the totality of the circumstances, lead him to think, is this something that's indicating criminal activity? He stated he checked her. Normally those things are having a warrant out, firearm activity, or drug activity.
And that's sufficient for the delay that was incurred if we look at Rodriguez? The delay and waiting for, let's just assume, okay, yeah, maybe he had a hunch, because that's all it could be at this point. How long does he have to verify that hunch? Has that time period elapsed that now the seizure becomes unlawful?
So I would say no in this case, because he is continuing to talk to her. He's continuing, even when he moves her to his vehicle, in an attempt to calm her down and continue to explain what's going on, why she shouldn't be driving this way, you need to be careful when you're out there, and then ultimately begins or starts writing a citation around 11:15. He testified that he did not finish writing that citation prior to the dog arriving. So from that to the dog arriving at 11:18, from 11:15 to 11:18 only being 3 minutes would be the time frame for the delay to consider. And that's, there's case law that provides 8 minutes is enough, that up to 15 minutes in a traffic stop is expected to investigate and then issue a traffic citation.
Go ahead.
Anyone have more questions? Go ahead.
I do. I'm curious about this reasonable suspicion, again, this reasonable suspicion standard. And if his suspicion is aroused by her story of where she went and came from not quite making sense, I'm wondering does that give rise to suspicion that of anything? Or does the investigation that the officer takes in light of his suspicion that her story doesn't hang together have to be targeted to what the source of the suspicion? So what I'm trying to get at is it enough to be curious about her route to trigger bringing in a canine rather than simply asking her more questions or taking her up on her offer to look at her phone to see whether indeed she had just been Googling where is the nearest speedway to wherever she was at the time that she Googled it?
I think the concern was he asked the question, multiple times, and there was no further explanation. So she certainly was given the opportunity to explain, this is why I went from this side of town to this side of town. And he gave her the opportunity that if that was a mistake, or if that was, there was a reason that she was doing all of those things, to be able to explain that to him. And when she did not, and the explanation that was given was driving from North Olmsted then to North Royalton solely to get a drink from a speedway, that's what rose the suspicion. Was why would you drive from one side of town to the other side of town to get a drink when he certainly knows in the area of North Olmsted there's a speedway over there? Then beginning down the line of thinking of, is this something that could be more? Is there criminal activity going on here?
I have to ask a hypothetical because we're at case and there's a lot of students here. But at sentencing, she mentioned she worked for Instacart. If she would have said that at that time, would that have taken away the reasonable suspicion of the officer based on her route?
I don't know. I don't know what's going on in the officer's mind at that point, but certainly it would give an explanation of why she's going to all of these different areas. I don't know the officer well enough to say, what he would think or how it would change his investigation, but certainly it would be important to note at that time or at any point throughout the proceedings.
And would it also be, is it incumbent on the officer if the suspicion that he's having is he's not understanding of the why? Is it incumbent on the officer to ask the question, why? Why were you doing that? If he never asked that, how can he expect her to have answered it?
And I'm not sure if that's what he was attempting to do, and continuing to ask, because certainly in the way of being like, what do you mean? Why would you go? Not why, but what do you mean you went from North Olmsted then to North Royalton? Did he specifically ask why? No.
Questions?
I have one, just in terms of the bigger picture. Certainly the reason why we have suppressions are to deter. And so given this scant explanation, how do we assure that the countless people that may have been stopped for such an alleged minor violation, they end up having to wait, have a dog sniff them, sitting in the back of a police car? How do we balance that? Because this really is more not about Miss Berg. This is protecting the people who got stopped. Could be my son, my daughter, my relatives. How do we ensure that they don't have to go through the experience that Miss Berg went through and they don't have anything?
Well, certainly, yeah, that's, as you had just explained, what suppression hearings, what, review hearings, review in courts, the position of those is to be checks and balances, certainly, and determine if this is a scenario that, this court does not agree with the trial court's decision and finds that there's competent, credible evidence against that decision, and then finding otherwise.
Questions? Okay, thank you very much. Appreciate
you,
your
Your Honor.
answers. Mr. Baker, you have your rebuttal time left.
Thank you. There's a lot to respond to here. I'll try to get to all of it.
Can I just interrupt you right
Sure.
before you get started? I want to ask you to address the question that I put to the appellee, which is, does the investigation that follows a reasonable suspicion need to be targeted to the source of the suspicion?
Well, the problem with the source of the suspicion here is that it's so generalized. She's nervous and she's not answering my questions straight. Okay, then what criminal behavior precisely is that indicative of? Because even the criminal behavior that was revealed, which is that she had a gun, it's not a revelation of any sort. It doesn't explain why she was nervous. It doesn't explain why she was answering the questions straight. So does the source of the suspicion in the questioning have to be targeted to the actual criminal behavior? I believe it should be, ideally. Does it have to be? I don't know the answer to that legally, to be fair. As I stand here right now, I don't have that answer. I do want to go back to something that the state argued, which was that it's difficult to tell whether she crossed the line. Frankly, it's not. It's not difficult to tell. This is a bright white line with a black tire driving over it. And it's on the line, and it only leaves the line when it's heading in the direction that it should. She never crossed it. That's not a traffic violation, and it's not reasonable to suspect a traffic violation that did not occur.
So what is your perspective on the tire and the line? Did she come in contact with the line?
She did. She touched the line. And
How
that's-
far? What would be your argument on that?
She would have to leave the line in the opposite direction that she did.
And in this case, what did she do according to your viewing of the video?
She touched the line. She drifted to the right, touched the line, and then left the line back to the left, which is where she should have been traveling in the first place. And that is not a traffic violation. The Ohio Supreme Court is clear on that.
Should we just look at what the judge opportunity to review?
Your Honor, my opinion is that the judge had the opportunity to review everything that is in the record in front of this court, but the judge did not. The judge chose not to go further and not to review that evidence. The judge could have taken longer in his deliberations and gotten a working copy, which this court now has, of the same video. He chose not to.
You're
And
saying his view of the video during the hearing wasn't sufficient?
if you want to give a full, fair viewing to all the evidence, no. And I do not believe that that constitutes competent, credible evidence. And I don't think that this court should lend credence to the finding that the officer had a good faith belief. Imagine what this would lead to. We already have WREN, W-H-R-E-N, which deals with the notion that no matter how minimal the traffic violation, and even if the officer admits that he's only pulling that car over because he's trying to fish for other greater criminal behavior, that's okay. And we already have WREN. We already have the, I forget the name of the case, but it deals with an officer making simply a visual estimation of a car's speed, not a radar detection of a car's speed, and that is sufficient in the officer's personal experience to cite somebody with speeding and to pull them over. We already have that. What is being suggested is that we take it one step further and say that if the officer merely believes that a traffic violation occurred, that's enough to pull the car over, and that's enough to fish for further criminal behavior. And that
Isn't that what the Supreme Court said, though, in Turner?
it's not, though. What the Supreme Court said in Turner is that there has to be a traffic violation, and there wasn't one in Turner. And so they reversed based upon that. And in fact, in reversing, it was a certified conflict question where a majority of the districts were on the side that I'm arguing now, and only the 12th district was on the opposite side. I'm not even certain that the 12th district as a whole was on that side.
Well, in Turner, though, the officer said the person did not cross the line. I mean, the whole issue in Turner was the officer said they were only on the line, and the Supreme Court said that's not good enough.
And that is exactly what we have here. We have a car, the holding in Turner is that it is permissible to drive on the fog line, and that is what she did. Now, the certified question was slightly different in dealing with crossing the fog line. The question, but the holding of Turner, which I believe came in paragraph 3, maybe 5, I don't have it in front of me right this second, dealt with traveling on the fog line. Lastly, as to consent, there was no consent because the officer merely told her, this is what I'm going to do. It wasn't like, if this is okay with you or could you do this. It was, this is what I'm going to do. And I would also note that the state never argued consent in the suppression hearing, so the trial court made no findings regarding consent. And lastly, the state noted that there are so many distinctions regarding the marked lanes statute in so many different ways that it has come up in all of these cases. And my answer to that is it keeps coming up in all these variations because police keep pulling people over for marked lanes violations that never happened. Thank you.
We will mark this case heard and submitted and issue an opinion as soon as possible.
All right. Hear you. This session of the Honorable Court of Appeals is now adjourned. The judges are going to have a Q&A.